March 2026. Visa Bulletin, EB2 India jumps 11 months. File I-485 now. The phone rang at 6:47 in the morning. A software architect in Seattle had been waiting 9 years for this call. His priority date had been locked in since early 2017. He had watched the Visa Bulletin every single month, sometimes twice a month, checking a number that barely moved. Some months it moved forward by weeks. Some months it retrogressed entirely, sliding backward as though the years he had already spent waiting didn't count. And then, on the morning the March 2026 Visa Bulletin dropped, his attorney called before he had finished his first cup of coffee. The words on the other end of the line were simple. You're current. File now. 9 years of waiting, 11 months of movement in a single bulletin cycle, and a window, narrow, urgent, and closing, to file Form I-485, the application that would finally begin the last leg of his journey to permanent residence. The trap that most people fall into at this exact moment? They celebrate first and file second. They tell their family. They call their parents back home. They take a breath they haven't been able to take in years. And by the time they sit down to start their I-485 package, the documents are incomplete, the medical exam has expired, and the attorney's calendar is booked 3 weeks out. The window is not waiting for them. Today, you're going to understand exactly what this Visa Bulletin movement means, who it affects, what the actual filing window looks like, and what you must do in the next 72 hours if your priority date is now current. For months now, there had been signals, not from the Department of State's official commentary, not from USCIS policy memos, just signals, that something unusual was building in the EB2 India category. The Visa Bulletin is published monthly by the Department of State. It governs when an immigrant visa number becomes available to a specific applicant based on their preference category and country of chargeability. EB2 India, the employment-based second preference category for nationals of India, has historically been one of the most backlogged categories in the entire U.S. immigration system. The backlog exists because demand from India in employment-based categories has consistently exceeded the annual per-country cap, which limits any single country to no more than 7% of the total employment-based green cards issued each year. For EB2 India applicants, the wait times have stretched for decades, not years, decades. The Visa Bulletin for this category had been moving in small, erratic increments for years, sometimes a few weeks forward, sometimes retrogressing by months when USCIS or the Department of State recalibrated demand projections. But immigration attorneys who monitor Visa Bulletin movement patterns closely noticed something building in the final quarter of 2025. The EB2 India cutoff dates were beginning to accelerate, not dramatically, but consistently. The pattern was building. The numbers were moving. And then, in the March 2026 bulletin, the acceleration became undeniable. When the March 2026 Visa Bulletin was published, what immigration practitioners described was a cutoff date movement for EB2 India of approximately 11 months in a single cycle. This is not a typical Visa Bulletin movement. In most months, EB2 India advances by days, sometimes weeks, occasionally a full month. 11 months of forward movement in a single bulletin cycle is an event. It signals one of 3 things. It signals that demand in the category dropped more significantly than the Department of State projected. It signals that visa number supply in the fiscal year is running higher than baseline utilization would suggest. Or, it signals that the Department of State is deliberately accelerating the date to consume available visa numbers before the fiscal year closes, and before those numbers are potentially lost. Practitioners weren't certain which factor was dominant in this particular movement. In practice, it may be all 3 operating simultaneously. But what was unambiguous was this. Applicants whose priority dates had been behind the cutoff for years, some of them for close to a decade, were suddenly current. And the window to act on that current date is not indefinitely open. The filing window created by this Visa Bulletin movement is real, but it is bounded by forces that most applicants do not fully understand until it is too late. The Department of State publishes 2 cutoff date charts in each Visa Bulletin, the Final Action Dates chart and the Dates for Filing chart. The Final Action Dates chart controls when USCIS can actually approve an I-485, when it can grant permanent residence. The Dates for Filing chart, when USCIS chooses to accept it, controls when an applicant can submit their I-485 package, even if the final action date hasn't yet been reached. Whether USCIS accepts the Dates for Filing chart in any given month is not guaranteed. USCIS makes that determination based on visa number availability projections. They publish their decision on the USCIS website. Typically, within the first week of the month the bulletin applies to. This means that even if the March 2026 Visa Bulletin shows an 11-month jump on the Dates for Filing chart for EB2 India, USCIS must confirm that it will accept filings based on that chart. If USCIS confirms, and the filing window is open, the clock on your preparation time starts immediately. If USCIS elects to use only the Final Action Dates chart, some applicants who are current for filing purposes but not yet current for final action will need to wait. This is the complexity that most people watching a Visa Bulletin headline do not account for. The headline says, EB2 India jumps 11 months. The reality says, verify which chart USCIS is accepting this month before you assume you can file. Let me walk through exactly what filing I-485 requires. Because many EB2 India applicants who have been waiting for years have not recently reviewed the full package requirements, and the requirements have evolved since many of them first filed their underlying petitions. Form I-485 is the application to register permanent residence or adjust status. It is the form that converts an approved immigrant petition, typically an I-140 in the employment-based context, into a green card when a visa number becomes available. For EB2, India applicants with an approved I-140, the I-485 package typically includes the following components. Form I-485 itself, completed, signed, and filed with the correct fees. Form I-693, the medical examination, completed by a USCIS-designated civil surgeon. This form has a validity period. If you had a medical examination done years ago in preparation for an eventual I-485 filing, it may have expired. The current USCIS policy on I-693 validity requires careful review based on when the exam was conducted and whether it has been sealed. Form I-864, the affidavit of support, required in employment-based cases when the principal applicant's employer is not filing a joint sponsor and the petitioner has certain financial obligations. This requirement is more nuanced in EB2 cases than in family-based cases, but it cannot be ignored. Form I-765, Application for Employment Authorization. Many EB2 India applicants have been maintaining status through H-1B or other non-immigrant visas. Filing I-485 makes them eligible to simultaneously apply for an employment authorization document, which provides work authorization independent of their employer-sponsored status. Form I-131, Application for Travel Document, allows the applicant to apply for an advance parole document, which permits international travel while the I-485 is pending without abandoning the application. Each of these forms has its own fee. The total cost of an I-485 package for a principal applicant with dependents can easily exceed $4,000 to $5,000 in filing fees alone, before the cost of a medical examination, document gathering, or legal representation. There is a group of applicants created by this particular Visa Bulletin movement that I want to address specifically because their situation is more complicated than a straightforward I-485 filing. These are EB2 India applicants who are currently maintaining H-1B status and who have been using H-1B extensions under AC-21. the American Competitiveness in the 21st Century Act, which allows H-1B holders with an approved I-140 to extend their status in 1-year or 3-year increments beyond the standard 6-year cap. These applicants have been in a kind of immigration limbo, approved at the I-140 stage, authorized to remain in H-1B status, but unable to file I-485 because their priority date was not yet current. For this group, the March 2026 movement is transformative. But it also creates a decision point with significant financial and strategic implications. Do they continue in H-1B status while the I-485 is pending? Do they accept the EAD they will be eligible for once I-485 is filed? And what does that mean for their employer relationship and their visa status? Do their derivative beneficiaries, spouses and children who may have been maintaining H-4 or F-1 status, need to adjust simultaneously? These are not simple questions, and the wrong answer to any one of them can complicate what should be a straightforward path to permanent residence. Let me address the dependent beneficiary question directly, because it is generating significant confusion in the EB2 India community right now. When the principal applicant files I-485, derivative beneficiaries, typically a spouse and children under 21, can file concurrently using the same visa number availability. This is usually the right approach. But there are circumstances where a dependent beneficiary's situation has changed since the underlying I-140 was approved. A spouse who was originally listed as a derivative beneficiary but who has since filed their own separate employment-based petition may need to evaluate which path offers better protection. A child who was under 21 when the I-140 was approved, but who is now approaching or past 21, needs an urgent analysis of Child Status Protection Act eligibility, CSPA, to determine whether their age for visa purposes has been locked in below 21 or whether they risk aging out of derivative beneficiary status. The CSPA calculation is not intuitive. It requires knowing the priority date, the date the I-140 was approved, and the date the visa number first became available, and applying a specific formula to determine whether the child's protected age falls below 21. For a family that has been waiting 9 years, it is entirely possible that a child who was 11 or 12 when the I-140 was approved is now 20 or 21. That child's CSPA eligibility needs to be confirmed before the I-485 package is filed. If they are protected under CSPA, they must file simultaneously with the principal applicant. If they have aged out and are not protected, filing them on the same package can create complications. This analysis cannot be done casually. It cannot be done the night before you submit your package. It needs to happen in the next 72 hours. There is one more dimension of this Visa Bulletin movement that I want to put on your radar, because it is the kind of information that doesn't make it into the headline, but determines what happens to the headline in the months after it drops. Visa Bulletin movements of this magnitude can retrogress. Retrogression means the cutoff date moves backward in a subsequent bulletin, effectively canceling the current status of applicants who didn't file quickly enough. Retrogression happens when the Department of State or USCIS determines that the pace of visa number consumption is outpacing availability. In fiscal year terms, the U.S. immigration fiscal year runs from October 1st through September 30th. If a category moves aggressively early in the year and then demand spikes in response to that movement, the Department of State may pull the date back to prevent overissuance. The March 2026 movement in EB2 India is the kind of movement that historically attracts a large surge of concurrent filers. Every EB2 India applicant who is now current, or who believes they may be current, will be attempting to file I-485 in the same compressed window. That surge in demand is exactly the kind of input that can trigger a retrogression notice in the April, May, or June bulletin. This is not speculation. It is a documented pattern in the history of EB2 India Visa Bulletin movements. The applicants who move immediately, who have their packages together, their medical exams current, their documents organized, their attorneys engaged, and their filings submitted within the first weeks of the window being confirmed open, are the ones whose cases are locked in. The applicants who wait will watch the date either hold steady or move backward. And if it retracts, they will be behind the cutoff line again. Some of them will have been behind that line for a decade. Here is what you must do starting today. Confirm your priority date. It is on your I-140 approval notice. If you do not have that notice accessible, your attorney has it. If you are self-represented, your USCIS online account contains your case history. Compare your priority date to the EB2 India cutoff date on the March 2026 final action dates chart and the dates for filing chart. If your priority date is earlier than the cutoff shown, meaning you are current, go immediately to the USCIS website and confirm which chart USCIS is accepting for I-485 filings in March 2026. If USCIS has confirmed the dates for filing chart is active, you are eligible to file. Contact your immigration attorney today, not this week, today. Attorney calendars fill within days when a major Visa Bulletin movement is published. If your attorney is already responding to the bulletin, they may be triaging by response time. Be first in line. Begin gathering your I-485 package documents immediately. Check the validity date on any prior medical examination. If it has expired, or if it is within 6 months of expiration, schedule an appointment with a USCIS-designated civil surgeon now. Civil surgeon appointments also book quickly in the wake of a Visa Bulletin event. Verify the status of every derivative beneficiary on your case. Run the CSPA calculation for any child approaching or past 21. Confirm that your spouse's documents are current and complete. Do not wait for a more convenient moment. The most convenient moment already passed. The next best moment is right now. As the March 2026 filing cycle continues, more details will emerge about how many applicants this Visa Bulletin movement unlocked and how the Department of State manages the demand surge in the months ahead. But one thing is already clear. Knowing this right now doesn't make you anxious for no reason. It makes you ready. It means you are not the person who finds out about this in April when the date has retrogressed. It means you are the person who filed in March, who locked in the priority date, started the clock, and protected their family's future before the window moved. Share this video with every EB2 India applicant you know. One conversation this week could save someone years of additional waiting. Subscribe to Visa Status Radar for more protection as the April Bulletin and USCIS responses continue to develop. We protect you with real information. Because in immigration, the window doesn't announce itself twice. It opens, and then it closes. And the only question that matters is whether you were ready when it did.